Good afternoon, and welcome to our presentation of Student Mental Health Navigating the Legal Landscape. I'm Pat Hovey, Executive Director of Thrive Alliance, and for almost about, I'd say close to 15 years, Thrive's been providing mental health supports and education for students and staff in their school environments. We work with schools to develop comprehensive mental health programming that raises academic performance, strengthens schools, and transforms lives. In that vein, today we're providing the opportunity for you to meet with two very respected attorneys well versed in education law. Catherine Gilfillan, there she is, has concentrated her practice in the area of school law, public sector law, and representing institutions of higher education. Kate represents numerous school districts in all areas of labor and employment law, special education law, residency, teacher and student discipline, contract preparation, public contracting, FMLA, FLA issues, and other student matters. And in addition to assisting with internal investigations, Kate regularly appears in the Office of Administrative Law for Civil Service and Education matters, as well as the Office of Civil Rights, U.S. Department of Education, Division of Civil Rights, the Equal Employment Opportunity Commission, and the Commissioner of Education in state and federal courts. Kate supplements her court-based advocacy with in-service training and policy and practice review to assist her clients in avoiding litigation. She regularly provides training in the areas of IEP development, IDEA compliance, cyberbullying, sexual harassment, teacher and student discipline, and the Americans with Disabilities Act and 504 compliance. Dr. Robin Ballard represents private and public school districts in all facets of special education law, including evaluations, eligibility program development and placement determinations, dispute resolution, and parents and disciplinary matters. She regularly attends IEP meetings and mediations conducted through the DOE and appears before the Office of Administrative Law for emergent and plenary hearings. In addition, Dr. Ballard often conducts in-service presentations on special ed and 504 issues for teachers, special services personnel, service providers in various districts, including preparation of legally compliant documents. She also has led training for employees of boards of education on effective strategies for dealing with difficult situations and to create more effective communication with parents. Robin's education and experiences while counseling and testing individuals with psychiatric disabilities have given her insight into the difficulties experienced by the special education population, which is the focus of her work. In addition, Robin is very familiar with mental health terminology and exhibits an extensive understanding of psychological and educational testing reports, as well as psychiatric evaluations. So, during the presentation, I'll be monitoring. I'm Pat Hovey. I'm going to be monitoring the chat for any questions you may have. And at the end of the presentation, we'll leave some time for anything that may not be resolved during the presentation. All right. So today, Thrive is excited to present to you our webinar with Dr. Robin Ballard and Kate Gilfillan. So I'm going to share my screen. So just give me a second. Can you guys see the screen okay?
Yes, thank you.
Great, great. I'm going to stop my video so they just see you guys and the presentation. And you're all set.
Great, thanks. We're very happy to be with you today and appreciate the opportunity to speak with you about the mental health issues. There is a bit of a crisis going on. Well, in our practice, we see that mental health issues are becoming much more prevalent. They're much more common. There are byproducts of COVID and the shutdown that relate to isolation and socialization and students' everyday functioning. There are a lot of mental health needs, and some of the needs are very significant. And we're going to talk with you about that today.
So Pat, can you turn to the first slide?
You got it.
So as you can see, COVID is obviously a major player as of late. However, certainly this slide is basically demonstrating the number of special education cases that deal with mental health issues from 1971 through 2021. Obviously, the significant uptick predates COVID. However, I think we're going to be seeing more of that in the general population. We have always had cases where we've had mentally ill students who we've had to place in specialized placements because we cannot service their needs in the general education population. However, because of the number of students and that mental health issues are affecting now, I think moving back into the general education atmosphere is going to be something that we're going to be seeing much more of. We certainly, the school districts, public school districts can't afford to be sending all of the students out that have mental health needs, and we shouldn't be. We should be accommodating those students within the structure that they are familiar and comfortable with, and moving them towards resolving their issues. So today we're happy to present, along with Pat, relative to the legal implications of what we're seeing in terms of the mental health crisis that's going on presently. And I think, Pat, if you could turn to the next page, we're going to start just with some recent cases. These are out of the Third Circuit. There's going to be some applicability and some differences to all circuits across the United States. We here in New Jersey are in the Third Circuit. We do tend to have one of the more lenient, more liberal circuits in the United States. So technically, where New Jersey goes, where the Third Circuit goes, we'll see some of the rest of the country kind of following. So today we're going to concentrate a little bit more on cases where they really are differentiating between mental health situations and students who have some social maladjustments, who would not otherwise be eligible for special education.
Right, and this is actually a very recent case out of the Third Circuit, the Northfield City Board of Education versus KS. And in this case, the student was referred to the child study team in 5th grade. She had a history of childhood trauma. The referral came due to struggles with math from her parent. And the team determined that no evaluation was warranted at that time, even though they were aware of the child's history of childhood trauma. The knowledge of the childhood trauma is something that would obligate educators to keep an eye on, but it doesn't automatically trigger a responsibility of the child study team to evaluate the student. In response to the student's struggle with math, and mind you, she was getting a C. Her parents didn't like her getting a C in that class when she was getting A's and B's in other classes, but the district offered tutoring and mentoring. She had some emotional problems of acting out, not getting along with certain peers, and her parent thought that she was depressed. So in response to that, the district offered counseling with a social worker, but again, didn't have a child study team evaluation. And the reason I talk about the child study team evaluation this many times already on this slide is because of the child find obligation. Districts are under a responsibility to refer any child who may be in need of special education to the child study team or its equivalent for evaluation for special services to determine whether they're eligible for special education related services. So then the child was hospitalized for 5 days for psychiatric reasons, and the district worked with the hospital to put a transition plan in place to transition her back to school, and the special education evaluation started. The result of that was that the child was classified with an emotional regulation impairment and was offered an IEP by the district. The IEP really just provided math support to her and counseling, and the parent initially agreed to the IEP and then challenged it. She filed for due process, claiming that the district had failed to appropriately identify her as a student with a disability by not referring her and not evaluating her sooner. Now, following the hearing, the due process hearing, the judge concluded that the IEP offered the student a free appropriate public education and that the district had not failed in its responsibility to identify the student as a student with a disability. Now, there's a little bit of a wrinkle that's not terribly relevant to our presentation today about whether she was entitled to compensatory education, because the IEP was not ultimately implemented because the programming in place at the time the due process was filed was her being a general education student. And so the district didn't implement anything. The district court agreed that she wasn't entitled to anything, and the Third Circuit upheld the district court's decision that the student had been offered a free appropriate public education and rejected the parents' argument that the student's disabling condition should have been found sooner. And factors that they looked at in terms of when the responsibility to evaluate is triggered is that the student had passing grades, her behavior at school was mild, and there was little evidence of emotion impacting her learning. So in this case, the parents ultimately were looking for an out-of-district placement, but they didn't need it, and so they weren't able to, they wouldn't have been successful anyway, but the judge did talk about how that wasn't an issue that was raised in the petition. Now, this case, MS versus Randolph Township Board of Education, I had the privilege of representing the board in that case, and actually in that case, Sage Thrive, I think it was called Sage at the time, but now as Thrive, was providing services to the student. It was a student with anxiety who had a 504 plan for his anxiety. The parents referred the student to the child study team through an attorney. The evaluation was conducted and the student was found not eligible for special education and related services. The 504 plan was continued. The student was provided with counseling services through Thrive, and the parents ultimately unilaterally placed the student in a residential program and requested due process, seeking classification as what emotionally disturbed, which now is emotional regulation impairment, and reimbursement for the residential placement. The ALJ found the 504 plan to be appropriate, and and also the district's determination that the student was not eligible for special education and related services, and denied the request for reimbursement. That decision was upheld by the district court. And the main factor there was that there was no evidence that the student needed specialized instruction to access his education. To be eligible for special education and related services, a student needs to need special education. And special education, we'll get into what the legal requirements are relating to that later. But in this particular case, the student took higher level classes than those for which he had been recommended and performed well when he was in school. And the judge just didn't find that there was any need to instruct him in a different way for him to access his education. So she upheld the district's determination that he was not eligible. And so this case is important in pointing out that mental health issues do not always equal eligibility for special education.
I think we say that all the time, right, Brian, that just because a child has a diagnosis, that does not immediately or automatically qualify them for either a 504 or specifically for an IEP. That it is this need for a very specialized instruction to access education. And we have time and time again, students who are diagnosed with anxiety, students who are diagnosed with depression. I would posit that it's really hard to find any high school students now who are not actually experiencing some form of anxiety, but it really, we have to stand back, look at how that's impacting the student and whether or not you need to teach the child in a specific way, which will drive whether or not they're responsible for or eligible for special education. Pat, could you do the next slide? All right, so I'll handle this one. This is again a recent case out of the Eastern District of Pennsylvania. Again, this would be a case going up to the Third Circuit. This is a student with 504. We have a lot of these cases where we have students who just simply stop attending school. They're school avoidant. And because the parent cannot force the child to get to school, it then becomes the school's responsibility, at least according to the parents, to get that child to school. We can talk every day from Monday about how we kind of allow children to develop so that they don't have these boundaries, and that when the child starts to act out, the parent then wants the school to step in. This is a case where basically the student stopped attending school. The parent had asked for home instruction. Of course, they would obtain a medical note from their physician that the child should have home instruction. The child was on a 504. The district did provide home instruction for a period of time, and the student was acting out and basically through a remote control at the instructor and hit the remote control, hit the instructor. The district stopped the home instruction. And then the following year, the child stopped attending school altogether. There was a behavioral support specialist in the home, as well as the student's physician asking for home instruction, which the district denied. And I think it's important to look at what factors the court was looking at. The supervisor in that case basically said this was a mental health reason, it was a behavioral health reason, and the better course of action would have to have the student attend school where he was going to be able to work with the licensed professionals that were going to be in the district to help him access his education, that it was a better place for the child to be than home instruction, because again, you're isolating the child away from his peers, away from other adults who can positively impact and positively reinforce that child. The court looked at the physician's letters and basically they spoke to a need for accommodating the student, but not that the child couldn't attend school. Now here in New Jersey, and I would certainly in all states in the United States, there are truancy laws that require children to attend school. I think it's very important that we make sure that our school districts are utilizing the tools that are available to them. It is always the parent's responsibility to get that child to school and to make sure that that child attends as long as they're within compulsory education age, and not going back on this, the child is too anxious to attend school. I think a lot of times what we see, at least in our practice, is that the child is doing fine, and then all of a sudden, it's just kind of a drop off of the cliff that happens, and then the parent's response to that is the child needs significant mental health supports. So in this case, the court sided with the school district. It was important to the court, certainly in our practice, the administrative hearing officers always ask us whether or not we have pursued truancy or a referral to social services that were mandated under statute to do as a school district. Those will always be important factors. So while we can work alongside mental health providers, we certainly want to make sure that we are following the rules that are out there for educating students.
And just dovetailing on that, there are so many issues that come up with the home instruction, with parents wanting their children to be at home. And I understand to a degree a parent not wanting the child to be around what is making them uncomfortable, at least according to the parent. There are times that we get requests for home instruction where the child is fine when the child is in school, and then the parent says, no, the child can't come. And particularly when the child is suicidal, I think that that's a very, very difficult sell, to me anyway, as to having the child be better served by being at home, where they're only going to be getting 2 hours of instruction per day in New Jersey, at least, rather than being in a school building where they're going to be monitored and around other students and have mental health professionals available to work with them in that setting. And so it is a balancing act. There are times that I've been yelled at by judges for not giving home instruction. In at least some of those cases, the parents hadn't given any sort of a letter saying that the student was unable to attend school. And actually, the case we talked about before this one, the Randolph Township case, the student did stop coming to school, but he was over the age of compulsory education. The parents did get a note for home instruction. He was minimally compliant with that. He wasn't cooperative with Thrive services. The parents weren't making him. Thrive was assisting the parents, but and we certainly appreciate Thrive assisting the parents, but they need to be assisting the parents in connection with the child. And so the student really needs to be part of that as well in terms of the effectiveness of it for the student's education. So,
Kat, can we have the next slide?
so has been a theme through the presentations so far, mental health issues do not automatically equal a need for accommodation through a 504 plan, and they certainly don't automatically require special education and related services, though many parents will think that they do. Many parents will come with their list of diagnoses. I've seen parents bring as many as 16 different diagnoses for a child and say, how can you possibly find that my child is not eligible for special education? Your child's not eligible for special education. There are criteria that have to be met to be eligible for special education, and a diagnosis, as Kate said, will not get you there. The diagnosis alone is not going to get you there. But that's not to say that mental health issues should be trivialized in any way. They are of significant concern, and schools are in a very good position. And you, as providers in the schools, are in a very good position to recognize mental health issues and the impact on students, and to make as Pat said in the opening, to make a positive impact on students' lives. And so making sure that the student is in the process of being noticed by school staff and intervention and referral services in New Jersey. I don't know that every state has one of these. INRS is actually relatively new. It was the renaming of something else from many years ago, doesn't matter. But that's the first line of defense, is it's a general education support that's offered where different staff sit down with the parents, they talk about the student, they talk about what's going on with the student, and they talk about supports that can be put in place. There will be times that students will show mental health issues following a significant change in the family, following a divorce, following the birth of a child, following
Death of a grandparent.
the death of a grandparent. If the grandparent lived with them, it's sometimes an even more significant impact that the schools are seeing. And so there are different ways that schools can offer support through general education, where there's no need for a plan, there's no for an accommodation plan, there's no there's no legality to these supports, but they should be offered. And if teachers are having concerns about mental health issues, if they see a change in hygiene or a change in the student's affect or even how they're dressing, if they have concerns about the student showing a great deal of anxiety coming to the front of the classroom to do a presentation, or
isolating from friends that they've traditionally been social with.
Right, staying by themselves in the cafeteria, and not by choice, because there are some students who stay by themselves in the cafeteria by choice. I have one of those going on right now. But those are things that parents need to be made aware of, and supports should be offered. But if the emotions rise to a level where it's impacting the student's education, a referral should be made for the child to be evaluated for special education and related services. Next slide, please, Pat.
So this is a New Jersey recent law that was just passed. I suspect that other states will be following suit, particularly if we're talking about California, New York, Massachusetts, some of the Pennsylvania areas, because mental health has become such a large part of addressing students' education. New Jersey passed a depression screening law, which basically requires districts to screen students in grades 7 through 12. They'll have to adopt a screening tool. It's up to the local departments of education to kind of establish what those screening tools will be looking like. School districts will, and providers will have to understand how to utilize that screening tool, how to assess students, and then the proper notifications that need to be made. The district is required to notify parent of an abnormal screening and advise the parent to seek care. Now, that is care outside of the school district. However, I think the impact and the import of what this law is meant to address is if there is an ability for the school to step in and counsel kids, or to be aware of students who may be prone to depression or have something going on, so that additional support can be provided within the general education program. You do need to have parental written consent in this particular situation. The law also allows, and this is, you know, going to the providers of these services, it does allow for the district to contract with mental health professionals in terms of addressing those needs for students while they're in school. I think we're going to see more of these as we come down the pipe. But one of the issues that this kind of brings up is the IDEA does not require districts to provide medical services. And there's such a thin line between what they consider a medical service and what's considered a psychological service, and or, you know, a counseling service. So really, you're talking about trying to divide out what really is a mental health issue that needs to be addressed as a health issue outside as a wraparound program, and what can be done in school. Traditionally, counseling that is done in school should be focused on school-related matters. So trying to make sure that the kid returns to class, developing skills or helping the child develop skills to navigate some of those more difficult days that they might be having. It's a skill-based, a skill development type of counseling that we are looking to provide in school districts. Not the type of counseling that you may get from a, you know, outside psychologist or licensed psychologist. Certainly not a medical or medicine-based program, but making sure that we're kind of staying in our lane, so to speak, while we're giving students counseling within school. Obviously, parents are, teenagers are always a source of strife, and obviously any counseling that has to address that. But trying to make sure that the kid understands that this is, you're in school now, this is where you're safe, and let's try and stay focused so we're not impacting our education, so we're not causing the child to be further behind, and then thereby creating additional anxiety, additional depression that's only going to leave the student farther behind.
Exactly. The focus it needs to be on making the child functional in the educational setting. And helping the parents support the child in being functional in the educational setting, because the word health is in mental health, and health decisions are for parents to make. We can't treat children without parental consent, and it's not the district's, it's not school's responsibility to provide health treatment. But again, it is a fine line, and it's something that the courts have wrestled with over the years, particularly with this population. I was going to mention before, and I just forgot, in the case law, I looked through to see if there was a good defining line for when the emotional issues reach the level of requiring special education. And I was not able to find any such bright line. There are some situations where students with very similar behaviors, the district finds the student not eligible, and the court upholds that. And in other situations, the student might be showing similar or even maybe less severe behaviors, but the team has found the student eligible. And the test that they use when a lot of these cases end up with parents seeking residential placement, and residential placement can be an option for students who are eligible for special education or related services, but it's necessary when the educational needs are inextricably intertwined with the student's social, emotional, and behavioral, and sometimes health needs, such that their needs cannot be met. They can't be teased out, such that the student's education could be delivered separately from the mental health treatment that the child needs. It's a fine line, and the courts interpret it differently. It's all based on, it goes back to a case out of Delaware in the 1980s, Poole versus Newcastle County, where the student did not have emotional issues, but had cerebral palsy and other significant cognitive deficits, speech delays, and things of that nature. But that was where the first case that really recognized the need for residential placement, at least in the Third Circuit. That's the seminal case. That's what it all goes back to. But it's difficult to draw that line, and it's also hard for parents sometimes to understand that in providing these services to support the student in school, you're not fixing the child. You're not taking away the anxiety. You're not taking away the depression. You're helping them gain coping skills and strategies to get through the day, and to seek out resources, and to help parents, or to help students know where to turn when they're having a rough day, and options that they can have, providing them with a safe space within the school building and trusted people to check in with, and things of that nature. So next slide, please. The criteria for, we've talked about the eligibility criteria in New Jersey. They define an emotional regulation impairment as a condition exhibiting one or more of the following characteristics over a long period of time and to a marked degree that adversely affects a student's educational performance. Due to an inability to learn that cannot be explained by intellectual, sensory, or health factors, an inability to build or maintain satisfactory interpersonal relationships with peers and teachers, inappropriate types of behaviors or feelings under normal circumstances, a general pervasive mood of unhappiness or depression, or a tendency to develop physical symptoms or fears associated with personal or school problems. Now, that's just the first prong of the eligibility test. You have to meet those criteria, and then also that condition has to negatively impact the student's education, and the student needs to need special education. And there are similar criteria in every state for identifying these students as potentially eligible for special education related services. So next slide, please, and then we'll talk about it a little bit. So what is special education? The Individuals with Disabilities Education Act defines special education as specially designed instruction to meet the unique needs of a child with a disability. And the federal regulations define specially designed instruction as adapting as appropriate to the needs of an eligible child under the IDEA, the content, methodology, or delivery of instruction to address the unique needs of the child that result from the child's disability, and to ensure access of the child to the general curriculum so that the child can meet the educational standards within the jurisdiction of the public agency that apply to all children. So this is something much more, the student in the MS versus Randolph case probably met the criteria for ERI. He, the categorical criteria, but he didn't need the specially designed instruction and there was an impact on his education, which is why he was qualified for the 504 plan, because he had a disability that created a substantial limitation on a major life activity, but he did not need special education. So that was the defining factor for him. The parents kept, and their attorney kept focusing on, well, how can you say he doesn't have this? We never really said he didn't have those things. We said he doesn't need specially designed instruction, and the court agreed. And there are factors that we'll get into later that the courts look at as to when a child with emotional issues might be in need of that specially designed instruction.
And I would just jump in and say these are the same factors that are set forth in the federal regulations in terms of the emotional regulation impairment. It's called a serious emotional disturbance on the federal level. I do want just to bring out that there's been there's a differentiation, right? When we talk about students who have been under this type of emotional strain for a substantial period of time, because the federal courts have actually come down and there is an exclusion in the regulations that speak to a socially maladjusted child. And what does that mean? And there was a quote in one of the cases. She says that the exclusion of a social maladjusted child makes perfect sense when one considers the population targeted by the statute. Teenagers, for instance, can be a wild and unruly bunch. Adolescence is almost by definition a time of social maladjustment for many people. Thus, a bad conduct definition of serious emotional disturbance might include almost as many people in special education as it excludes. And I think that one of the things as we counsel students and as we counsel parents and deal with the educational impact of mental health, that we need to be very clear on is, are we within kind of what the norm is? We expect students of a certain age to kind of act out from time to time. That doesn't necessarily mean that a child is emotionally disturbed. It does not mean that the child requires that specialized instruction, that specifically designed instruction. And that is adapting the way something is taught to a child, the content of what is taught to the child, or the manner in which it's delivered. That would be when a child is so impacted and requires special education. The fact that a child has a disability that requires additional time, they have anxiety, that's a 504 issue. They really need to be able to say, we cannot access what my peers on my same level would be accessing without this specific mental health issue. So I think that it's very important as we go through this to ensure that we're understanding and explaining to parents what is kind of within the norm, what we expect when we are classifying students, that this has got to be something that has been maintained over a long period of time. Going back to the point that Robin had made when we were talking about students who are going through a difficult time, right? Letting the child adjust, having sufficient time to adjust to that new situation before slapping a label on a child, because we do have to recognize that that in and of itself may cause a child to feel less than they would otherwise. All right. Next slide. So this is one of the lists that I had come up with for some of my clients, and it's basically some questions, and it would change from child to child. But when we're dealing with mental health and education, the things that we want to know from their treating psychiatrist or from their treating psychologist as to how we can best service them and best accommodate them within the school district, and really being able to kind of tease out some of the psychological from the educational requirements for a child. These are the types of things that we really want to know as a school district, and you as providers, how are we best addressing this, for a kid? We have many cases where the response is, this is what their treating physician says, and how can you go against it? We say this all the time. As school providers, we don't diagnose children. Providers should not be dictating the educational prescription for students. It is the school district's responsibility to take all of that information in, to figure out how they can educate a child with all of that information, with the limitations that are noted. So I'm sure Robin's had them. I have reports on my desk every day that says this child requires a residential placement without any kind of basis for that, other than the child happens to have depression, is struggling, mightily with peers and with parents. But this is the kind of just a sample of the types of information. If I were going to talk to a physician, or if we were going to have somebody on the stand in terms of talking about cross-examining them, what is the information that we need as a school district to help service the child while they're in the general education program? Because the focus is always maintaining the kids in school. That should always be the focus, is to ensure that the child stays in school as much as possible within the general education programming. That's the school district's requirement, is to educate them regardless of what disability they have, but it is always as close as possible to what they would normally experience in a school district.
Absolutely, and things get clouded between, it's again, the clouding, the fine line between the health piece and the educational piece. Parents will bring letters that say, I have one right now that sent in 3 letters from different providers. One, the pediatrician, one was the physician's assistant, and one was a counselor, that all said this child needs a therapeutic placement. Parent is refusing to accept that the district has a therapeutic placement available because they have derived services there. The parent will not bring the child to school and keep saying, how can you go against the recommendations of the doctors? It's not that we're going against the recommendations. The law requires us to consider their opinions, but Kate's absolutely right in that, we don't tell you how to do your job. Please don't tell us how to do ours. So factors that the courts look at in regard, and factors that you should be aware of and be paying attention to, are the student's social skills. Social skills can significantly impact a child's education, because education is a broad concept. It's much more than just academics. It's social, emotional, and behavioral. And if a child is having difficulty socializing with peers, playing, participating in group activities, things of that nature, that's concerning, and it does potentially indicate a need for special education. But the courts will look at things like, does the student have friends? Does the child participate in extracurricular activities? And in many of these cases where the parent will say that the student needs to be in a residential placement, they have friends. They are participating in extracurricular activities. And the court says, the residential is extreme in those circumstances and is not necessary for educational reasons. The court also looks at the student's academic performance, and it's not just grades, it's the level of the classes. As I was talking about before with the MS versus Randolph case, the student was in extremely high level classes, higher than what he had been recommended for by his teachers, and yet he was doing very well when he was in school. And so that indicates that he does not need specially designed instruction to be accessing his education. It's certainly an indicator of that. The behaviors, this gets to what Kate was talking about before, where there's some degree of acting up that is normal. There's some degree of acting up that is expected. But then there are behaviors that will rise to a level where the student is just disrupting the educational environment. I spoke with a district earlier today about a child who literally is like climbing up on chairs and desks and is generally wreaking havoc on his kindergarten classroom. But and that's something to pay attention to. But also you can bring in a behaviorist. You can have the behaviorist observe the class and offer strategies for how to impact student behaviors within the classroom, to see what impact that has. Because we always want to look, as Kate was saying before, we always want to look to keep children as typical, I put that in air quotes because I'm not sure what the typical child looks like, but as typical as possible. Whether the child's available for learning, if they are displaying really poor coping skills, and if they're participating in class. Those are things that you look at. If a child is just not learning it hasn't made progress, you can't demonstrate them, and shuts down, head down, not participating, not handing in work. And there are some kids who will do that willfully. I had a case many years ago where the parents wanted residential placement for a student who was ultimately classified as emotionally disturbed. And her highest grade was a D, but we successfully defended the appropriateness of the IEP that placed her in district because she wasn't doing any work. She just wasn't doing any work. She had a part-time job. She was out with friends every night, but she wasn't doing any schoolwork.
And just as a kind of an aside, I know a lot of folks say, well, we can't ask about medication. We can't talk to the parents about what level of classes the kids should be taking. There's no legal support for that. You can't mandate students, at least in New Jersey, you cannot mandate that students be on medication. However, you can absolutely ask about it, and whether or not they, if it's going to be impacting them within the school day. You can't force people to tell you one way or another, but it's a perfectly acceptable inquiry to make. That's the same for level of classes. I have many districts who don't want to go up against either the student or the parent who've asked to take an honors class or an AP class. And if you have students with high levels of anxiety who place a lot of pressure on themselves, due to academic grades, it's perfectly acceptable to say that is going to increase your anxiety. It is okay to go down a class. Let's see if we can work around that. We do have to, of course, modify the honors classes or put in accommodations. We don't have to modify the content, but certainly put in accommodations to allow them to access that information. But that is also an extremely important conversation. I think we tend to shy away from those conversations now because we don't want to disappoint anyone, but those are conversations that we say all the time really need to happen. And they've happened for years. And it's just been probably in the last 15 or 20 years that folks have kind of refrained from giving their opinions about, look at, this is a way in which to address anxiety. You don't put as much pressure on yourself by going up to those AP level classes. I think it's really hard when we look at students today in high school who are taking 4 or 5 or 6 AP classes. Of course, those kids, that's not, in my life, that's not a normal way in which people conduct themselves. That's a lot of pressure. In the real world, we all have deadlines, but we all get extensions. So it's a lot of pressure for kids, and it's okay for school districts and for providers to address that directly with students and with their parents.
It absolutely ties in with their mental health needs and what is appropriate to address their uniqueness as a student. And they often don't want to hear it. The student in the MS case said that he would not go to school at all if he couldn't be in the higher level classes. So his parents put him in the higher level classes, and then they maintained he was too anxious to perform in those classes. And he had a lot of anxiety, and he did struggle. He spent time in hospitalization programs. And so it's not to minimize his anxiety, but the anxiety level, the district in that case did recommend that he go to a lower level class, that he stay with what the teachers had recommended, and the parents said no, and the district had a policy of allowing the student to take whatever level class. And even if you have the policy, you still can have the conversation. You can and should have the conversation.
I think the next slide, Pat, I think we've kind of covered, and I know we're running a little
Yes.
short on time. So if we could go to the last slide, I think we're perfect. So in terms of mental health providers who are contracting with schools, I think there's a couple of rules that we think we would touch on today. Specifically, when you're providing services in the school, you are acting as an agent of the school. We have had a number of cases where we've had difficulty getting documents out of mental health providers, but those are school-related documents. They are related to the students' educational programming. So just as a reminder, that is kind of the rule if you're contracting with schools, that the provider plays. We'll say all the time, you document everything and then you document nothing. We know that all documentation will come back. When we talk about documentation, we certainly would like to see, when you have goals and objectives that you're working on with the student, making sure that you're talking about whether or not the student is making progress, but really objective type of things. What is the strategy that you're working on? Were they able to adequately employ that strategy during the week? Was there an opportunity for them to employ that strategy during the week? Documentation such as that really assists in ensuring that we are providing the correct services and focusing on the correct goals for a student.
And if I can just jump in there for a second, parent training is also, I know, a large part of what you do in terms of going into the homes, working with parents. And the documentation can be very helpful in terms of giving the parents a roadmap for what they need to do to implement what you have talked with them about. And so giving them it's not an instruction manual, so to speak, but it's, like, here's the issue and here's what you can do. Here are different strategies that you can try to employ. Here are different, and if you're making recommendations for modifications within the home, for example, if the student is in his room all the time, but has a TV in there, has access video games, has a computer in there, taking the electronics out of the room is, I know, a recommendation that has been made and is often not followed through on. But if you're recommending that, document that you're recommending that. It just helps in terms of giving feedback later, to say, when the parent will turn to you and say, well, we've done everything, and you say, but I see the computer in the room, I see the TV in the room, I see the video games in the room. Here's where we talked about you should take those out.
And I guess one other word of caution in terms of the term that I have heard is we're recommending a higher level of care. When that term is utilized, it is interpreted by parents as meaning that the child cannot be serviced educationally within the school district. And I don't think that that has always been the way in which the term was meant. Generally it is meant they need to go see a specialist, or they should be in a partial hospitalization program or a partial day program. And what that looks like from an educational point of view, we have students all of the time that go out and access their care and then can return. That doesn't necessarily mean that the child needs to be in a separate setting. It just means for that period of the day or a part of the day, the child needs to be in a different setting where there are a higher level of supports for that child with respect to whatever issue they're facing. I constantly liken mental health issues to, being treated for cancer. You have to go out and you have to receive your treatment. And then once that treatment and whatever the impact of that treatment is, we as the school district have to work around what that treatment is and work around the impact of that treatment. And then just on the tail of that, making sure that we're managing expectations of parents, having real truthful conversations with them about what mental health illness is, what mental health issues their child is facing, and the real source of what those issues are. There are numerous times that we have been met with the argument that the child's dyslexia was not addressed, and therefore the child became depressed. Therefore, the child became anxious, and it becomes this kind of which came first, chicken or the egg type of conversation. But saying to a parent, no, a mental health issue is a separate type of disability that needs to be addressed, separately. Obviously, depression can always impact how a student is performing in school. But again, our role is as educators, our role as providers within a school district is to make sure that we are supporting that student so that they can stay in school as much as possible, just to really kind of normalize their lives.
And just jumping on that, I had one last thought, which is that if if you're seeing a need for a higher level of care, this isn't to suggest that you should not be suggesting that. It's just that you should suggest that they speak with their private providers about whether a higher level of care is needed, rather than overtly saying he needs a partial hospitalization program or an intensive outpatient, and here are programs that I would recommend. Because once you say here are programs that I would recommend, you're working as an agent of the school, and then the parents turn to the school and say, well, are you going to pay for that? And the answer is always no, because it's it's health treatment, and it's nothing that we can make the child go to. So your instincts, we're not questioning your instincts. There are going to be children who do need a higher level of care, but we just would suggest that it's cleaner to suggest that they speak with their own providers as to whether a higher level of care is needed, and to document that. So thank you all so much. This was our pleasure to be here. Are any final questions?
So I think you actually answered the questions as we went along. So nicely done on your part, ladies. Appreciate it. Certainly, if anybody has anything you think about later, or scenarios or situations that you're in, you are more than welcome to email us, contact us at Thrive. We can certainly send that message to Robin and Kate's way if we can't help you. But if there's no other questions, I am going to close the meeting and wish you all a very good day. And thank you so much for joining us.
Thank you.
Thank you.
All right. All right.
Thanks,
Thanks,
guys.
guys.
Good
Talk
to
to
see
you
you.
soon.
Yep.
Just if anybody has any questions, I'll send it on to you guys, and just check in. I really thank you very much for doing this.
Sure.
Anytime, our pleasure. Thank you.